Hello, everybody. Welcome. Um, I'm John Haig. I'm the co-director of the Mosava Rahmani Center for Business and Government. It's also terrific to see so many students from the class that John Salad and I are teaching. You just have us all day today, right? We've got this seminar from noon to 1, maybe go a little over. Then we've got class from 1:30 to 2:45. And then there's another study group as to somewhat a continuation of this topic at 4 o'clock, if you can make it to that. So it's terrific to see so many of you here. Today is one of the key kind of discussions, it seems like post-election, what's going to happen to the tech sector. And I know the dean, Jeremy Weinstein, had reached out and was hoping that various centers would do some work on pre-election or post-election kind of implications. And I think now is a terrific time to do that. We have our usual crowd of people here. We have Tom Wheeler, former chairman of the FCC. John Salad is here, just walking in the door. And he's a lawyer working on the Google antitrust case at the moment. But our main speaker today is Gene Kimmelman. And Gene was a former Deputy Associate Attorney General at the DOJ, so incredibly familiar with various antitrust issues and continues to work in that area. He also has an affiliation at Yale, but we don't hold that against him too much, anyhow. And he is a senior research fellow here at the center. But as I said, the topic today is election competition and big tech. And with that, John, Gene, it's all yours.
Thank you so much, John. And welcome, everybody. Hope you're finding the food. We're going to talk a little bit about the election results and how it may shape tech policy in the US and I think beyond. I want to start off by saying that I think in thinking about the election results, for me, this is not the topic that I think is the most important, maybe not even one of the 10 most important topics. So I just want to acknowledge that up front. There are a lot of important implications of this election, but we're going to focus on tech today. So just to put that out there. And I want to thank Harry Park for helping me, research assistant here, for helping me pull this material together. If you don't like the slides, it's Harry's fault. So here's the way I want us to think about this over the next hour. We're going to look at what we know or what we think we might know about who is going to lead this new administration and its enforcement agencies and the Congress. Really look at all elements of the federal government that impact tech policy, and then ultimately the courts. And I want to do this broadly because in reality, there are so many pieces of government that impact any area of policy, particularly tech policy, and it would be inappropriate to focus too narrowly on just one. So I want to kind of lay it all out with what we know. So with that, let's start with the Department of Justice. President-elect has announced that he's going to pick Representative Matt Gaetz to be his Attorney General. Now, if any of you have been following this, there are some issues around the confirmation process. This will be the case with many nominees, but certainly with Matt Gaetz. There are a lot of questions that are being raised about how that will work, whether there would be a way around a direct confirmation process through what's called recess appointments. I am not going to go into all the details of that. We could do that later in the study group if you're interested in it. But let's just look at Matt Gaetz and what that would mean. On tech policy, he was one of the supporters of legislation in the House of Representatives that would have led to a breakup of many tech companies. Representative Jayapal in the House Judiciary Committee sponsored a bill that would have prohibited what she called conflicts of interest in tech platforms that also own services that ride on their platforms and would have required divestiture. Viewed as a pretty extreme bill. It never moved in the Congress, but Gates was a co-sponsor of that bill and supported other legislation that would prevent self-preferencing and discrimination on tech platforms. What we have up here is a piece of a letter that he actually just wrote recently, as after Judge Mehta, Federal District Court Judge Mehta, found that Google had violated the antitrust laws, was engaged in maintenance of monopoly for its search business. Gates and Senator Lee in the Senate, we'll come to him later also, wrote a letter to the CEO of Google saying, you had better comply, and you better not do anything to start circumventing what might be remedies, including what might be structural remedies. So this guy is actually pretty tough on the major tech platforms. We don't know what else he would do in this space, but certainly in this area, he has a long track record of thinking that there needs to be a change in policy governing tech platforms. But there is more to the DOJ process, and we don't know how the Gates nomination will unfold. So I wanted to look a little bit about what happens now. There's a transition between now and the inauguration, January 20th and 21st. The new team will come in, but there is a transition team, and being led by a number of attorneys who are close to the president-elect. And what jumped out at me about this is, besides the fact that these are people very close and have worked on the defense of the president-elect on a number of the lawsuits he's been involved in, very clear cut on what they expect of DOJ employees. Now, it is always the case when a new government comes in, career staff are asked to follow the leadership of the new administration. But I don't believe I've ever seen anything quite so pointed as to pretty much say, if you don't think you're going to be obedient, you should really leave right now. This is quite heavy-handed and hard-hitting. What we also know, since they put out this statement, is the president-elect has selected one of his top lawyers, Todd Blanche, to be nominated as the Deputy Attorney General. That's the #2 position in the Justice Department, former prosecutor, also a lawyer for Donald Trump. And he has selected Emil Bove, another one of his close defense attorneys, confidants, to be the chief deputy to the Attorney General. And I highlight this in the context of this slide. Emil Bove will definitely be able to walk into the Justice Department on January 21st, will be the top appointed person, does not need Senate confirmation. And whether or not Matt Gaetz is in the building or is going through a process of being reviewed by the Senate, or whether or not someone else acting would come in, Emil Bove will be able to run the Justice Department on January 21st with this kind of directive to the attorneys there. So what does this mean for the Department of Justice? Well, again, let's stick to the tech area. At least for antitrust cases, there are a lot of cases that are going on right now. And so I'm not going to do everything that might touch tech, but just to me, I think are highlights of major litigation that could be transformative for competition policy in the United States. So we have the Google search case, which is in the remedies phase. Our colleague John Salad is involved in that, so he won't talk about it. But this is really important. With a finding of monopolization in search, Judge Mehta now enters a phase where he says that by August he will decide what the remedy is. There have been a variety of proposals put on the table that could include everything from vast data sharing of Google's treasure trove of data that it controls through the search ecosystem to possible divestiture of Chrome, Android, maybe other assets. So a broad array of issues, could be very hard-hitting remedies, some maybe not as hard-hitting, but this is all on the table. There's a case involving the online display advertising industry where Google has been alleged to have violated the antitrust laws by the Department of Justice. Judge Brinkma is heard full evidence in that case, is indicated that she's likely to rule by the end of the calendar year. She's going to at least try to, where Google has a strong position both on the sell side and the buy side of display advertising and runs an exchange. Government alleged monopoly power in each of those segments. And so if the ruling there is that Google has violated the antitrust laws through monopolization in this sector, it is the government had asked for a divestiture remedy, that they be required to sell a substantial portion of their positioning in this market. So that will be impacted, probably going very early in the new year. Department of Justice filed a case against Apple for monopolization, using its smartphone leverage in its iOS Mac ecosystem to maintain its monopoly positioning there. That case is scheduled for trial in 2026, I believe. And there's reporting that the Department of Justice may have started an investigation of NVIDIA's practices in the chip market. So 2026 is far away. This administration will be well down the path of being in place and really in the saddle riding things. A few decisions that'll be made early on, and then that will be a major case unfolding as we proceed. A lot to come at the Department of Justice with a requirement of loyalty to the president. We don't know what that means. But then there's the Federal Trade Commission, co-equal player in overseeing antitrust, dividing cases, investigations based on industry sectors with the Department of Justice. Lena Khan is the chair. It is the tradition when the opposite party wins the White House that political appointees step down by inauguration day. So that's the anticipation here. So what happens then? Well, there are two Republican commissioners, Andrew Ferguson, Melissa Holyoke. It is most likely, and traditionally the case, that one of them would be immediately named acting chair to take over. Now, it's possible at the rate that the president-elect is going in picking new people for his cabinet and agencies that he will name someone else or them, one of them earlier, to be the permanent chair. This is an interesting situation where because the Democrats in charge now have a 3-2 majority, and we expect Rebecca Slaughter and Alvaro Bedoya to stay. Lena Khan, in theory, could stay on as a commissioner for some period of time. It is not unheard of, but it will be really up to the administration as to whether they would desire that. Usually, incoming administration does not want that. They'd rather, even though they don't have the majority of commissioners yet, they'd rather have it 2-2 rather than 3-2 against them. They will clearly be nominating someone to fill Lena Khan's slot over time. Could be quickly, it could take time. But again, the tradition is that the chair would step down in most circumstances. So open question still as to longer term, who runs these specific agencies. Let's peek a little bit into the process and see what we know so far. Gail Slater, who was an attorney at the FTC 15, 20 years ago, working for Commissioner Julie Brill, a Democrat, and had done work in the commission on antitrust cases, ultimately ended up as a close advisor to now Vice President-elect J.D. Vance. She has a substantial background in antitrust. has been involved in a lot of antitrust policy work. Um, and she is overseeing the transition team process as it relates to uh, antitrust and tech policy. Hard to believe that she would not have a voice in personnel matters. And she may even have her own personal interest in going in and taking one of these slots. But she's certainly doing the review, and people's names have come up. Mark Metter was an attorney in the antitrust division in the policy area, then went to work for Senator Lee. He was a detailee from the Justice Department, and has now got his own firm. Um, Todd Zwicky was at the FTC. There are a number of names. You don't always know whether the names being floated are the likely people, but it does give you a little bit of a feel. Macon Delrahim, who was the Assistant Attorney General for Antitrust in the first Trump administration, there's been articles floated to indicate that he might be interested in running the FTC, or they might be interested in him running the FTC. So a variety of people who have a background um, in antitrust and some experience, which is always a good thing. But I want to remind you of that first general DOJ slide I shared you, which is everything we know about the people who have been picked so far, and what the people who are running the transition say is it's all about loyalty to the administration. So that's the bottom line I take away. But then, as this has been playing out in real time, there's also a little bit of a cloud over the FTC that I just thought I would flag for everyone. It has nothing to do with the election. This has been going on for a while, but there are legal challenges to the structure of the agency and the constitutionality of the way the agency is structured, with an administrative review process internally overseen by the commissioners themselves, who run the agency, but then get to make the decision once an ALJ has done a preliminary ruling. There have been constitutional challenges out there. This is one legal commentator who is highlighting that as new people are coming in to run the agency, there could be determinations coming in the next year that vastly diminish, or at least adjust, the powers of the agency going forward. So that's just something to keep in the back of our minds, that there is this question about the structure of the FTC that is playing out in the courts. But then what about the FTC cases? They have a number of important tech cases. In a very recent ruling, Judge Boasberg, District Judge Boasberg, has ruled against Meta's summary judgment challenge of a monopolization case that the FTC brought, originally filed in the Trump administration. I should point out too, I didn't at the beginning, the Google search case was originally filed in the first Trump administration. So there's continuity here that is at least somewhat bipartisan. This case was filed originally in the Trump administration to challenge Meta's behavior in purchasing WhatsApp and Instagram, alleging that these were part of a scheme to actually block competition through acquisition. Judge Boasberg ruled that there is an adequate basis for this case to go to trial. No trial date has been set yet, but that will proceed. So that will be interesting. The FTC has filed a monopolization case against Amazon, alleging abuse of its online marketplace platform, its use of Prime, leveraging others, driving up prices across its online merchant ecosystem. That case will go forward to a 2026 trial. Unclear what the remedy request was, but certainly indication that there would have been, under Lina Khan, a request for some divestiture if Amazon was found to monopolize that market. And there's just been reporting too that the FTC opened an investigation of Microsoft. Now this is for cloud computing practices, abuse of its cloud software. This is on top of the FTC having earlier challenged Microsoft's acquisition of Activision, which, although the FTC lost that case, The FTC has been preparing, after a loss in federal court, of bringing it back to this administrative process that it has in the agency that I mentioned is under this other legal cloud. And the question there is, in the new administration, will that proceed? Will that continue? We're waiting for a Ninth Circuit ruling on the Activision case. If it's overturned, then it goes back to the FTC anyway. If it's sustained, there still is the question of whether there'll also be some administrative process the FTC seeks to use to challenge Microsoft's practices. So all of this is ongoing. I should also point out that in terms of beyond the Meta case, there is separately a dispute about a consent decree Meta entered into with the FTC for abuse of privacy practices. And the FTC has sought to adjust the way it can fine Meta for abuse of that consent decree, being challenged by Meta also in court as to whether that exceeds the FTC's authority. So there's some combination of issues there, I would say both on the Microsoft side and on the Meta side, that could get sort of intertangled at some point. So these are the major antitrust cases in my mind that need to play out in a new administration. But there's other really important policy areas that we need to look at. Trade. President-elect has made it absolutely clear that he is all about tariffs, and he is all about using trade practices as leverage against other countries, against the companies in other countries, to try to benefit what he thinks is the best market result for the American people. So he's got a very strong mindset that way. Robert Lighthizer was his head of the trade office, USTR, in the first administration. He was trade rep. He is known as the tariff czar, and he has been signaled that he is coming back to this space to be a real czar, not just have the characterization that there could be some new position created. But I just read this morning too, his name has popped up as possible Treasury Secretary as well. One way or the other, Lighthizer, who is known for being extremely aggressive on using tariffs, on leveraging trade practices to affect other policies, is going to be a big player in this administration. Other key roles are the head of the National Economic Council, the Secretary of Commerce, who the U.S. trade rep in the new administration. We don't know yet. I haven't seen any names for those yet. But I think regardless of who that will be, we're in an era where trade practices are going to be elevated as tools of leverage. And I have to believe tech will be among one of the major areas that is affected that way. So that's a little scan of the executive branch as we've seen it so far, but then let's now swing to the Congress. Major shift, obviously, with this election, Republicans taking over the Senate. What does that mean? Keep in mind that this isn't just, when I say Congress, this isn't just about legislation. Congress plays the fundamental role in the funding of all the agencies, oversight of the agencies, engagement with the administration on all kinds of policies, and uses its power of the purse, uses its authorization process and appropriations process in general to push its own vision of policy in any sector. So what do we know about the new players? This is it's a little hard. It's a big institution. We have 100 senators. John Thune was just named majority leader, not a huge player in tech in general, has been a bigger player in telecom. But clearly the fight to become majority leader involved a number of issues where the candidates all had to effectively pledge allegiance to the new incoming president. And Thune did that as well as the others. Time will tell how that plays out, but I think we're in a world where there's going to be a big push coming from the White House, and we'll see how the majority leader reacts to that. Chuck Schumer is the minority leader. will lead the opposition, um, uh, was very engaged on pushing for some AI oversight and regulation, um, not as engaged on some of the other tech antitrust or other policy matters. But he was kind of the traffic cop as majority leader and just not getting in the middle of things. So open question as to where he falls in the opposition now. Senator Grassley will be the chair of the Judiciary Committee, and he has co-sponsored some bills to put non-discrimination requirements on major tech platforms. I'm not sure how high up in his list of priorities this is, but this is at least a sign that he's willing, he believes there is a need for legislation to do something to create more accountability in the tech sector. Susan Collins will run appropriations, not very actively involved in these issues. And Ted Cruz runs the Commerce Committee. He has been very actively involved, very deregulatory minded. Um, he's was one of the few people who opposed the Kids Online Safety Act that went flying through the Senate with vast bipartisan support. But I think he's going to bring a very deregulatory mindset to this. His other major issue area is censorship of conservative voices in the media and online. And so that will be something we're going to see bubbling up from many, many places. So those are our Senate leaders. Let's look at the House. Here we have continuity pretty much. We'll have a new chair of the Commerce Committee. I've heard it's likely Representative Guthrie, but possibly Bill Arrakis. Others are known better. Here, the speaker has not been very actively involved, but certainly Congressman Jordan, as chair of the Judiciary Committee in the House, has been very aggressive in challenging a lot of the practices of the Federal Trade Commission, some of the use of their power, questioned some of the cases that they've brought, questioned the leadership structure and how they've used the power of the chairman's office. So very, very aggressive in raising questions about Chair Khan, generally not viewed as a big friend of big tech, but certainly a very deregulatory minded congressman. And much of his action has been actually in raising questions that some of the major tech platforms have raised themselves. So I think there'll be a big push there also on the censorship issue, as they describe it, question of whether there's a bias among the tech platforms in how they do their content moderation practices. Okay, so that's the lineup there. But regardless of how Congress comes down looking at these issues, we still have the courts. And I didn't put the Supreme Court up here, but let me just start there because this one to me is just very, very obvious. This is a very conservative Supreme Court, has been for a number of years. Generally, antitrust cases do not make it up to the Supreme Court, been very few and far between. Those that have, I think there's at least a strong question of how open to aggressive enforcement many of the justices would be. Some of them as appellate judges have been very critical of government prosecutions and theories applied. I think where this will most likely be relevant is if there ever is a breakup order to a major divestiture remedy coming out of either the Justice Department or the FTC. You're going to see extensive scrutiny from the more conservative Supreme Court. But as I said, very few cases will get up there. So let's look at where the action really is. Court of Appeals, the circuit courts, which also generally are unlikely to ever hear or see a merger case come up. Usually they're time limited, and when a decision comes down blocking a merger, you sometimes hear rumblings about appealing, but often the companies abandon if they've lost, and usually because they have some kind of agreement on a time limit, and the appellate process is often a year plus added to the process. But certainly any conduct case, any monopolization case, would be likely to go up on appeal. And here we've had a shift in the course of the Biden administration. There have been a lot of appointees. Um, Now, it's always a crapshoot. You don't know what judge you're going to get, but I just wanted to point out the general numbers here to highlight that there's as good a chance or not that you could get a Biden or Obama judge or a set of judges on the appellate panel in any case that comes up. Even more clearly for the district court judges, um, clear majority that Democratic presidents have put there. Now, it's not political as such. They're all applying the law. They're all following the guidance of the appellate courts and, of course, clearly the Supreme Court's jurisprudential judgments. But again, since many cases never make it up on borderline calls, on novel theories, on particular kinds of remedies, it's likely to be in front of a particular judge. So here really there are more opportunities for judges selected by Democrats to weigh in. What that will mean, we don't really know. The Congress is back in session now until Christmas in what's called a lame duck session. There are at least 14 judges they're hoping to vote on, nominees. But as you do your math here, you'll see I think there still are 30 plus slots out there. And my guess is, unless something happens really dramatically here, those would be positions filled by the president-elect's team once they're in. Here, I think, again, think of the piece parts. If you think some of these cases look like they are ones that would carry forward, certainly involve the Trump administration at the outset, Google, Meta, and that we get through findings of liability as we have in Google search, could be in ad tech, we'll see on Meta. These bubble up through to the appellate level. Pretty interesting chance here that you'll have judges who are sympathetic to the way certainly this last administration thought about antitrust enforcement. So I think we could see a number of cases really go forward. Now, I do believe that if anything does get to the Supreme Court, it's more likely a divestiture or breakup kind of remedy. And we'll have to see how the court would look at that. But I just want to stop on that for a minute. To me, divestiture and breakup are not necessarily more left or right or any kind of characterization. In antitrust, it's always the question of what the harm is, what the violation of law was, and what is the remedy that actually fixes it and sets the market on a course forward that will diminish the likelihood of the abuse, prevent the abuse, open the market to competition. So these are not Republican Democrat issues as such. It's a vision of what really works. And if you don't do a divestiture and you don't do a breakup, the other kind of remedies tend to be much more ongoing agency oversight, court oversight, sometimes with special masters, sometimes special committees, that are much more regulatory. And those types of remedies are often disdained more by Republicans who do not like big government, big regulation, extensive regulatory intermingling with corporate practices, meddling with corporate practices, they might say. So I think this is kind of a bit of a crapshoot as to how all of that plays out. But moving away from just this pure antitrust part of it, what we do know already about the courts is that there have been a number of rulings on regulatory power that I think are indicative of the mindset of the Supreme Court. And these involve different aspects of regulatory decisions and actions. But overall, each one of them, in my mind, is a sense that the administrative state is out of control in the minds of the Supreme Court majority, needs to be reined in, needs to be constrained. And each of these involves some analysis of how much deference to give an agency in its judgments about its powers and how it can apply those powers. ranging from an analysis of exactly how specific was the Congress when they gave an agency power to whether something is what they call a major question. Major question being something of major economic and social importance, where it's not absolutely clear cut that Congress said this is what you have to address. So think about this. This is actually one of the most important sets of cases in modern times, in my mind, of how we think of government functioning, because invariably, almost every regulatory agency I can think of, at least, has some fairly general guidance from Congress, maybe some specific things to prohibit, to limit, to focus on, and then some general guidance as to, and don't allow this to happen in the future as things unfold in this market, as technology changes, for example, as practices in the sector change, which has always been viewed as fairly essential to functioning regulatory activity. And here the court is saying, no, no, we don't believe that. We think we as judges are better positioned than the expert agencies to determine what Congress really was allowing you to do and not allowing you to do, or what you should be allowed to do under these major questions. So this is going to fundamentally affect rulemaking going forward. It has been already bubbling up in the last couple of years. So let's just stop on that for a minute. That has come up before when we thought about what my friend Tom Wheeler and John Sallett pushed through the Federal Communications Commission, which was the net neutrality ruling, where there were back and forth different interpretations, but there was deference given to the agency. We've had this come up. One of the major cases here that led to this doctrine was some of the EPA regulations on emissions. But in this administration, with this set of precedents, I'm not sure how this is going to play out. Could be really different. For example, the president has just named Brendan Carr to be his nominee to run the FCC. Very smart guy, been very vocal out there pushing the idea that the FCC should be preventing the major tech companies from abusing their power censoring conservative speech. There are no FCC rules that I know of that address this issue. It's even a major question, I think, as to what powers within the FCC he would be applying. He's also said he's going to review the licenses of broadcasters who are still licensed to the FCC to serve the public interest and make sure that they're not abusing the public interest by somehow being biased against conservative speech. That public interest standard has been there for a long, long time. I don't know that it's ever been applied this way. So are those kinds of rules going to withstand this kind of scrutiny by the courts? Now, the courts themselves could say, we don't like you agency doing this. We don't think you should be doing it. It's a major question, but we kind of agree with you. We, the courts, will establish that. But that would be a major question issue. It would still have to be within the statutory authority granted the agency. There's a lot of stretch here that could be looked at in many ways, but I take these court decisions to be actually a substantial constraint, potentially, on a new administration that wants to take existing law and apply it in a very dramatically different way. Let's use another example. The FTC, they have power to launch investigations. They have been looking at AI, for example, and some of the AI hiring practices, some of the partnerships. They have the ability to subpoena documents through what's called 5B studies. They can look at a broad set of sector practices and whatnot. That's what they've been doing. But what if they launched a rulemaking, and they just had a rulemaking on non-compete clauses? That is one of the things being challenged on this whole constitutionality question and agency authority to prevent companies from using non-compete clauses with employees to prevent them from being mobile and able to actually get a market price for their value of their labor. But this FTC could have a major rulemaking on preventing tech platform censorship as well, right? Because that's what they seem very, very worried about. Using that same broad FTC authority, unfair and deceptive practices. Is Google engaging in unfair and deceptive practices? Meta? I think a whole lot of this will be subject to some of these same very stringent legal standards that the Supreme Court has established. So this is one that I think has effectively been a set of court rulings that could hit both sides of the political spectrum equally hard in efforts to try to be creative with existing legal authority. So with these directions from the courts, the ongoing cases out there, let's turn back to the other thing Congress sometimes does. What's the chance of seeing anything new enacted, new legislation in this environment? We went over who the leaders were. That was not very clearly informative. But if you look at the recent bills that had been put in, there's at least some interesting questions here. I start with the America Act. This one never got direct much attention. Senator Lee is the sponsor. Senator Klobuchar, who was the chair of the Antitrust Subcommittee, probably will be the ranking member now. He'll probably be the chair. This effectively was a bill that prohibited a conflict of interest in companies that own the platform doing digital advertising, display, and any content flowing on those platforms. Effectively a bill that would have dismantled Google's display advertising business. Similar to what the ad tech case is about as an antitrust case. This was introduced by Senator Lee. This could very well come back. Again, I don't know how broadly it would be supported by other Republican senators, but certainly it had Democratic support. So to me, that's a very interesting one. The Open App Markets Act is a bill that is a little bit like I'm described to you the Apple monopolization case related to practices around abusing smartphone power in the Apple ecosystem. This is directly about how that is applied in the Apple App Store and preventing any kind of self-preferencing or discrimination against app developers, alternative app stores trying to market through the Apple App Store or the Google Play Store and build a separate store. This is sponsored by Senator Blackburn from Tennessee, Republican from Tennessee, who will be a new major player there, and Senator Blumenthal from Connecticut, who was the lead sponsor. Now it flips. That went through the committee 3 years ago with an overwhelming bipartisan vote and then had stalled. I could see that coming back. The Kids Online Safety Act, which is fundamentally about setting a duty of care for tech platforms in treatment of online content vis-a-vis children, that passed the Senate just a few months ago with overwhelming Republican support. You recall I mentioned Senator Cruz was one of the opponents of it, but it's already been through the Senate. There's some talk about whether this could actually get done in this last month of Congress, if the House would go along with it, if the incoming president signaled that. I mean, that's probably a long shot. But it could easily come back next year, and again, had a lot of momentum. So that's not impossible, I don't think. There are a few others that have gotten a little bit of attention. Senator Klobuchar's Innovation Choice Online Act went through the committee again 2 years ago, then stalled, been stuck there, had some bipartisan support. This is non-discrimination on tech platforms. And then there's the creation of a digital agency. And while that's a real long shot, I think the Klobuchar bill probably is too. The interesting to me about the digital agency idea, other than the fact that we've been trying to promote it for years here, is that Senator Lindsey Graham, who will be one of the senior senators on judiciary, one of the lead senators for the Republican Party in some leadership role in the Senate, is is the sponsor, along with Elizabeth Warren from Massachusetts. And this would create a kind of an agency to augment what antitrust does with very broad powers to oversee tech sector practices. So I'm not going to hold my breath and say any of these things is likely to happen. Um, but I don't think we should disregard the possibility that there could be some thirst in a Republican-led government to legislate. And if it's just focused on kids, even if it's just focused on censorship, the only thing we can always know about the legislative process is once it gets going, other issues often arise or get added, and there are compromises that come up. So I just want to flag any of this is possible. Not likely, but possible. So beyond our little ecosystem here, remember I brought up trade and tariffs. There's the rest of the world. So let's at least take a peek at some of the other important things going on in the rest of the world. And this will not be comprehensive. I just, again, picked out what I thought were kind of highlight issues. And I'll just say I picked out the issues that struck me that if they proceed as they look like they are, would be the kinds of things the US tech companies would be most apoplectic about, most likely go to complain to the White House about, and where this whole question of are we using tariffs and trade tools to push back against other countries' practices and policies, where I think this could arise. So we'd recently, the European Commission just did a sizable fine, imposed a sizable fine on Meta for abusing its marketplace practices, tying Facebook Marketplace to its core service. I'm sure Meta is appealing that, but clearly the Commission is continuing to be fairly aggressive in its antitrust enforcement in Europe, at least now. There will be a new Commission coming in. Margrethe Vestager is stepping down now as we have Commissioner Ribeiro will be coming in, but I doubt much will change on the big policy issues there. But there is at least that chance of some change in Europe as well. And the European Commission, similar to the Justice Department, has filed a case against Google for its ad tech practices, monopolizing the ad tech market. And it's one of the few examples where Europeans have signaled that they believe a divestiture is required here too. Usually they don't speak to penalties right up front. But that is going forward. And as if you've followed any of our other lecture series here, we've talked about the Digital Markets Act, a little bit of the Digital Services Act, a whole new set of regulatory requirements that are being implemented in Europe as we speak. I'd say the key ones right now that will be possible lightning rods in this country will be the Commission's claim that Apple, and I think derivatively Google, if it really finds this way on Apple, is abusing its power in how it runs its App Store, requiring it likely to adjust its fee schedules and opening up the opportunity for interoperable access to alternative stores and information about the prices and options available in alternative app stores. Apple is fighting aggressively against the Commission on that. I'm sure we'll appeal anything they decide, but that could be a major watershed case in Europe that drives policy changes, business practice changes, and will certainly not be viewed positively by Apple or Google here. Similarly, the Commission has found that Meta is violating its Digital Markets Act and privacy law requirements in how it is establishing a payment structure for avoiding advertising on their platform. So I think a large fine is possible in that case as well. And then the DSA, what I just flag here is they have identified X as being in violation with some of their advertising system requirements under the Digital Services Act, again threatening a large penalty. What will happen with all of these regulatory enforcement matters and antitrust cases in a world in which the US posture is that we're going to use tariffs, including tariffs on Europe, as a tool of promoting what this administration will view as US policy. I want to then move quickly to the UK because it's not just the European Commission. Here we have a new Digital Competition and Consumer Protection Act that is just about to take effect. We have a children's online safety law that's also taking effect. And these are going to involve a different set of legal requirements and approaches, but effectively many of the same issues that the Europeans are looking at, the CM, Competition Markets Authority in the UK is looking at, and again, could impose fines, could go further and seek structural changes with the companies, and also will face similar kinds of leveraging. So where does this leave us? I've presented you kind of a hodgepodge. The easy thing to start with is that we have this short term here before Christmas where there's a lame duck session. Is there anything that could pass? I think probably the only things are the Kids Online Safety Act, but that would require President-elect Trump to say that he wanted that to happen. There was talk about some AI legislation. I haven't highlighted that here because the only thing I've seen that is plausible is kind of transparency or labeling, nothing that really involves substantive regulation around AI. But since everyone cares about AI and talks about AI, it's not impossible that Congress will want to do something that's called AI. But very likely, very, very little. I'm going to come back to number 2 last. There is, with the control of the Congress in the hands of one party, an additional tool that usually is not available in legislation, which is normally legislation just requires a majority to pass the House of Representatives, but the Senate rules have always required a supermajority, often described as the filibuster rule, 60 plus votes needed. That has been used to temper the whims of the slight majority and protect the goal of a Congress that is seeking greater consensus. Doesn't always work that way, but it has been an impediment to passing legislation without broad support. With the control of both the House and the Senate, there is one other tool legislatively that is available to Congress, which is a special rule for budget bills that involve determining the spending levels for the government going forward for discretionary spending, not mandatory spending, not Social Security or Medicare, discretionary spending, which often can include some level of directive to agencies within government as to how they spend the money or what they're allowed to do or not allowed to do with the money. It's called the budget reconciliation process. With control of both the House and the Senate, this bill only requires a majority. It is the only one that will be a pure up and down majority vote. There will be enormous pressure to package anything that this administration wants into that bill because it is got the greatest likelihood of passing Congress. So we will see that unfold in 2025. We will see how all these trade leveraging points play out. We will see how Europe and the UK move forward or adjust their enforcement practices as they work with the new US administration and try to figure out how they can avoid steep tariffs and other trade sanctions of sorts. And of course, what we don't know is whether this administration will back down on some of the cases or adjust some of the remedies that the current Justice Department or the FTC have been proposing. Now, let me stop on that for a minute. Almost every one of the cases I mentioned to you, what I did not mention was we have state attorneys general who are partners in those cases, who have filed along with the FTC and the Department of Justice. And usually, I think I didn't look carefully, but I'm pretty sure every one of these cases has both Republican and Democratic state attorneys general. Some of them have more Republicans, some of them have fewer. But the states will make their own determination on whether the cases go forward from their perspective and whether the remedies being sought are the same as the federal government or not. We've had a split on this before when government changed around 2000, 2001 in the Bush administration in the Microsoft case. The Department of Justice settled for some terms on a remand of an appellate decision that some states objected to and continued to litigate. So I just flag there are state actions connected with these federal actions that will be relevant both to whether the federal government changes posture because it might not feel comfortable abandoning the states or being in conflict with the states, or whether they do it and the states move forward anyway and the cases proceed as they might have done coming out of a Biden administration. So I flag that for you, but we don't really know how that'll play out. But the final thing I want to come to is the filibuster rule. This is not likely, but it's not impossible that this rule could go away. And here's what I'm thinking. If it turns out that this government wants to make substantial changes in policy, including agency powers, agency tools that are available, wants to abolish certain agencies. We've been hearing about ideas of how to shrink the government. And they can't pass legislation because of the filibuster in the Senate. They can't get 60 votes. They can get 50, but they can't get 60. And if there's some items like that that cannot be put on the budget reconciliation bill, because they really are not budget items. Now, again, something could change, but the Senate has a parliamentarian, usually is not partisan, selected by the majority leader, but usually is not partisan, who tends to follow the precedents of the Senate. Those are very narrow definitions as to what can be in a budget reconciliation bill. So it could change again if they pick a different kind of parliamentarian, but I'm guessing there will be substantial constraints on this administration legislatively. The only way I can think of around that is to call for the elimination of the supermajority requirement for legislation. Now, it doesn't have to be done across the board. It could be done for matters that involve national security. It could be done for matters that involve some vision of what the First Amendment is or something like that. It doesn't have to be everything, but it could be everything. And all it takes is a majority of votes in the Senate to change that rule. So I don't know that'll happen. I don't think it's likely to happen, but it could happen. And then that puts everything in play of what the majority is willing to change in terms of federal government structure and policy. So on that note, I will stop at the study group. We can come back to any of these issues and talk also about the nomination process and recess appointments and all of that I skipped over. But that's the world as I see it. Thanks.